What's going on, Houston? This is attorney Cory Roth with Cory Roth Law Office. I'm a Houston-based criminal defense attorney, but with a practice all across the state of Texas. I will go where my clients want me to go. And that is why I'm talking to you today. 2017 is very quickly wrapping up. I have had 5 trials. 5 trials. 4 of those trials, actually 3 of those trials were my own clients. 2, I was hired at the very last minute to try for another attorney. My 3 trials, 3 not guilty verdicts. The other 2 trials where I was not the attorney of record, not the hired attorney. I got a hung jury on a case I definitely should have lost, or most attorneys would have lost at least. And I got a guilty verdict out in Liberty County on a very, very tough theft case. But the good news is we beat what the judge, we beat the offer, and we beat what was requested by the prosecutor from the jury for punishment. So in a sense, it's a win. In a sense, I know if it was my case, I would have worked it up a bit differently, and I think I would have got a different result. But that's neither here nor there. Let's talk about the cases that I've tried this year. We're going to focus on the one that I just tried out in down south in Brazoria County in Angleton. First case, my client's charged with public intoxication and failure to ID. This is in the city of Sugar Land. I don't try many municipal cases, but this was a good one. It was worthy of being tried. My client's a passenger in a truck at the drive-thru on January 1st, about an hour into the new year. And my client is pulled out of the truck by an officer for absolutely no reason at all. His arm's ripped out of his socket, and we're going to sue, by the way. We're going to sue the city of Sugar Land for violating his civil rights. And then they arrest him for public intoxication and refusal to ID. Prosecutor didn't understand that this was a really terrible case. My client did not do anything wrong, and you cannot detain somebody unless there's a reasonable suspicion to do something wrong. Lo and behold, on the day of trial, prosecutor dismisses the failure to ID because my client was not lawfully detained, and I get a not guilty verdict on the public intox. And mind you, my client there was an odor of alcohol coming from the car. He had trouble. Vinny, stop. That's my dog. He had trouble standing. He was in a whole lot of pain. I think for most attorneys, jury would have came back guilty. But I worked harder than the opposition. I worked smarter than the opposition, and I won. Second trial was a really wild assault family violence case where my client, he ends up testifying and admitting to kicking his family member in the chest while she was sitting on the front porch. Jury was out on that one for 17 minutes. Wild case. Lady calls up my client claiming to be her daughter, asking if he can come live in his extra house. He says yes. She shows up from California with 9 kids. She doesn't take care of the kids at all. My client, a grandfatherly figure, gets very concerned, make sure the kids go to school, make sure that they're well taken care of, make sure that they're healthy. And mama's gone all day, probably off, working a motel room or something. And client gets upset, and he calls the police, and they don't show up. So he goes over to her house, which is actually his house, and wants to see the kids. She won't let him see them. He ends up kicking her in the chest, and cops show up a little bit later. He walks back over there, doesn't think he'd done anything wrong, ends up being arrested. That client, both those 2 clients were actually referrals from previous trial day dismissals. So we end up getting a 17-minute not guilty verdict in this assault case. While he's out on bond, just about 2 weeks after he's originally arrested on this assault, he picks up a violation of protective order and kidnapping. I unfortunately did not represent him on the kidnapping. If I did, man, we would have tried that case because he saved that kid's life. And I don't think a jury would have convicted him, especially having the experience of knowing how much that my jury in this assault case hated the mother. So this last case, before that, there was a theft case in Harris County. Somebody looking like my client is, mind you, this is not my hired case. I was hired to try it. Somebody looking like the client is caught on camera at HEB stealing some very expensive blenders. Officers are able to track down a truck through the license plate. The owner of that truck shows up, meets with the cops when requested, and gets visibly sick when they confront him. And this guy says, "Oh well, it was my brother. He looks a lot like me, and sometimes he drives my truck." So we went forward on that theory. We were married to it. We were stuck to it, especially because what the other attorney did during leading up to the trial, giving some evidence that I would not have given to the prosecutor. I wouldn't give them any ammunition to fire back at me. That just doesn't make sense. So we ended up trying the case, and one of the issues was whether my client actually had a brother who looked like him, and we introduced pictures, and we had somebody testify. And Judge Fields, Harris County Court 14, I'm charging you extra if you're in there. He specifically ruled that we were not allowed to get into the issue of a Mexican birth certificate because we didn't get a certified copy. Case is going well. The officers testify I get them to admit everything that I needed them to admit. They didn't catch anybody red-handed. They didn't recover the property. They didn't get any fingerprints. They couldn't rule out the possibility that somebody else who looked like my client was driving that truck. Of course, this baby prosecutor gets up there during closing argument and says, "You never heard anything about a Mexican birth certificate." I object. Sustained, which means that the jury can't consider it. Asked for a limiting instruction, which is granted, and I asked for a mistrial, which was denied. Why do I want a mistrial? Well, now the jury heard that there might be something out there, and she shifted the burden to me. I was very upset by it. And the jury could not reach a decision, and we got a hung jury, and about 10 minutes before we picked a jury for the second trial, which I felt better because we got that verified, certified Mexican birth certificate, client decided to take a deal, and it wasn't a good deal. He ended up getting screwed way more than if we had lost and the jury had assessed punishment. But that was his decision. So this last trial was a possession of marijuana down in Brazoria County. My client is pulled over for his rear license plate light being out. Now, the law of Texas doesn't say anything about the license plate light, whether it has to work or not work. In fact, so he's driving down the street, has a company truck, and he gets pulled over by a Pearland Police Department officer for the license plate light being out. In reality, the officer couldn't read the license plate, even though the license plate lights were working properly. Why? Because the positioning on pickup trucks of the lights are further away from the license plate, and my client had the standard issued plate from 2009, that dark, blue, hold lots of colors, which was discontinued because law enforcement was complaining about it because it was too hard to read at night. So the Department of Motor Vehicles canceled it. So my client's pulled over. He's acting a little weird. Gets out of the car before he gets into the parking lot. This is because the officer, I won't say his name, but he's pretty useless, overzealous rookie. Didn't know how to work the bullhorn on his car. And my client pulls into a well-lit Exxon parking lot, and my client's eyes are red, and officer asks him if he's drinking. He says, "Yes, I've had 2 beers. Officer goes back and runs my client's name and supposedly hits a warrant out of Harris County for a toll road issue. Officer calls for backup. Backup arrives, and the officer asks my client to step out to do a field sobriety test. And during the mental part of that test, that's where they determine whether you still have your mental faculties, to see if you have slurred speech, to see whether you could formulate your thoughts. The officer asks a series of questions over and over again, and my client is very consistent. 2 beers, Shiner box. I stopped drinking 2 hours ago. I came from Sugarland. My client's doing well. The officer asks if he smoked anything, and my client, I'm going to stand up for you. My client says, "Not that I know of." Officer follows up. "You sure there's nothing in that car I need to know about? No weed, no guns, no pot, no drugs?" "Not that I know about." I made body language part of the issue in this case. State wanted to argue that showed guilt. Who doesn't know what's in their car? Well, his reptile mind, his subconscious mind, made the decision that it was going to communicate for him, that he posed no risk, that he had nothing to hide. So my client passes the mental portion of the test, and he passes the eye test, the horizontal gaze and nystagmus. And after that, the officers step back to have a conversation, and my client says, wait, my lights are working. And the officer says, well, they're working now, but they weren't working earlier. Kind of nonsense is that? So at that point, the first officer, the arresting officer, and the second officer have a discussion. And the first officer says, did you smell the alcohol? The other officer says, nope, no alcohol. What was your PC? License plate lights. I turned them off a couple times. Well, you got no PC. He's not drunk driving, no bad driving facts. And then the first officer says, well, he's got that warrant. He's got that warrant out of Harris County Precinct 7. And the other officer says, I don't verify those. See, in order before an officer can arrest you for an out-of-county warrant, it has to be verified, and that requires them contacting their dispatch contacts dispatch for the county or the department that issued the warrant, and sometimes they verify, sometimes they don't. So during this point, there's what we call an unlawful extension of the detention. What Pena should have done is called in for that warrant verification before conducting the field sobriety test, but he didn't. In my opinion, that was an illegal stop, and we filed a motion to suppress before trial, and we lost. The first motion to suppress I ever lost, but I knew I had a second bite at the apple, and I raised those issues again, and I did get a jury instruction on a couple of different issues as far as the illegal stop, the illegal search, and the illegal motivation. So why does this officer decide to arrest my client for a non-violent, non-dangerous, out-of-county traffic warrant? Well, it's because he has a hunch. He has a hunch that there's weed in the car. My client admits that he just smoked pot at the place he just came from. So the officer decides to arrest him on that warrant. Now, of course, the officer denies. He's like, I didn't suspect anything. I figured I would never get back into that car. Well, that's nonsense. That's nonsense. And I know it's nonsense because when the officer comes back to the scene later to pick up the weed, he does this celebratory motion. And I went over that with the jury during jury selection. So he arrests my client so that the other officer will be required to conduct an inventory. And that's when they go through your car when they tow it to account for valuable properties so that they won't be accused of theft or you won't have anything stolen from you. So that's fine and dandy unless that's fine. Vinny, stop talking. That's fine and dandy unless that the officer has a motive, a ruse, an underlying improper reason for that arrest so that they can search you. And in this case, the cop clearly had a hunch, which means that the inventory was illegal. So where do they find the pot? They find the pot in the front passenger floorboard, inside a nice Samsonite backpack, and inside that backpack was a laptop and an ounce of pot. It's just pot, but this could have been cocaine, could have been meth, could have been crack, could have been Xanax, could have been prescription pills. It could have been anything that made this much more serious and something that I would be much more proud to write home about. But it's still pretty awesome because it's pot. And it's a county where lawyers do not get not guilty verdicts very often. Most lawyers lose there. So what do we find out? We find out it's a company truck, okay? The only thing found in that truck was a prescription pill bottle in somebody else's name, somebody's name other than my client's. But on the other hand, you have this bag of pot with a nice backpack, with a nice laptop inside it, found very close to my client. So there, state's arguing, well, he admitted to smoking pot earlier. His eyes were red, indicating he was high, even though he passed the field sobriety test. He was the only occupant of that truck, and the marijuana was within his reach. I, of course, demonstrated how hard it is to reach all the way across a truck, and I brought out from the officer that they didn't find a single thing inside that truck, inside that backpack, identifying my client. And they knew that it was owned by somebody else. And they could assume that because it was a company truck that other people were in that truck and other people drove that truck. So I got the officers to admit I got them to agree to certain things. I'm not going to give those things away here. But I got them to admit some very important things. If they didn't admit those things, well, they would have been seen as liars. They would have been seen as being dishonest. So we were kind of nervous about this case because marijuana was found very close to my client. But I did a very, very lethal job of cross-examining both officers. And look, the fact of the matter is the government has to prove beyond a reasonable doubt that a person knew about the drugs. It's not enough that the drugs were found near them or in a place where they have access. They have to show knowledge. There was no odor. There was nothing in plain view. There was nothing identifying my client. They didn't get fingerprints. They didn't do anything. There were reasonable doubts. There were plenty of reasonable doubts. And this jury followed the law. They held the government to their standard, and they found my client not guilty. So for my clients this year, I went 3-0. I went 0-1-1 for other clients where I didn't get to build up the case. I put that record up against any other attorney. I wish I had more trials. Sometimes my good cases often are dismissed. They're dismissed, so I don't get to try it. I don't get to pad my stats. And I'm fine with that. But at this point, I've been practicing for 4 years. I've tried probably 15 trials, motions dispositive, motions to suppress, and I have not lost my own cases. I've not lost a single trial or a single motion to suppress, and I've won many for other lawyers who've hired me on to try their cases. When you have an attorney who is getting those kind of results, it's obviously going to cost you. The most expensive decision or mistake you're going to make is hiring a cheap lawyer. It's going to cost you more when you fire them and you go decide to hire a good lawyer, or you're convicted and you have to file an appeal. Failure to ID, assault, possession of marijuana, and, by the way, a second theft, public intoxication. By the way, in my 3 cases that I tried, where it was my clients, in the possession of marijuana case in Brazoria County, after I got that not guilty verdict, they also dismissed the possession of dangerous drugs. After I got that not guilty in the Harris County assault family violence case, they dismissed the kidnapping case, and I think my client pled guilty to violating a protective order. Time served, never had to go back into jail. And on the that Sugarland public intox case, which is so easy for a state to win those, they also dismissed the failure to ID. Hopefully, y'all watch this video. Hopefully this builds some confidence, makes you want to call me. Vinny, come here. Come here. Trying to get my dog. Come here. Come here. That, by the way, hey, Vinny, is my office dog, pit bull named Vinny. I look forward to meeting you, helping you out. Hopefully we can get a good result, not guilty verdict, dismissal, or anything in between. My name's Cory Roth, known as Attorney Roth. You can visit my website at attorneyroth.com or call us 713-864-3400. Look forward to meeting you, helping you out.